All right, so we've got Robert Long and Jason Seibert up here to talk about regulation of ICOs, token sales, and kind of how some of the compliance issues are around it, and I'll let them take off.
All right, hey, thank you very much. We are going to take some time today and just kind of go back and forth and discuss the regulatory environment in particular with an emphasis on the ICO space and what has resulted from the SEC's DAO token report. But we've got Jason here with me, so I think we're just going to kind of maybe pose some questions to each other and take questions from the audience. So we're here to kind of get you guys the information you're looking to obtain.
So was everybody here for the regulatory panel that we had earlier, or are you here new? Show of hands, who was here before? About half. Okay, so for the new folks, I'm an attorney, former data engineer in the Air Force, worked on cryptography at NORAD, took care of all the mainframes, got out of the military, was a data engineer with a few phone companies, built out wide area networks, et cetera, transitioned from data engineering into law, studied securities law under former SEC General Counsel Mike Eisenberg during the subprime crisis, and so developed a focus on securities regulation. And then Bitcoin was created, and when I swore I'd never go back to data again, I actually found out that I have like the perfect marriage of both of my worlds, former data engineering and cryptography with securities regulations. And so I try to look at all of these projects in the cryptocurrency space by walking both worlds, by walking both the data engineering and creation and programming side with also the regulatory scheme. And so that's my background. I will give you a little bit of a warning. I'm a little touch of Asperger's, and so I have a tendency to maybe be a little bit too abrupt. But that's not me trying to be offensive. That's just me in my programming way. Rob, on the other hand, he's the smooth talker. And he used to work for the SEC, but I'll let him introduce himself. Yeah.
Sure, thanks a lot. Worked at the SEC, both in Washington, D.C. and in Fort Worth, Texas, for a total of 10 years in various capacities, from a senior attorney, branch chief, to trial attorney. I also worked at the U.S. Attorney's Office in Phoenix, Arizona as an assistant U.S. attorney, and then also as a special assistant U.S. attorney in Dallas. I also worked at the Financial Industry Regulatory Authority, or FINRA, for, maybe just under 3 years. And basically my background is largely as a regulator. About 3.5 years ago, I left kind of that government/quasi-government background to go to private practice. And so now I work at the law firm of Bell, Nunley, and Martin, which is in Dallas, Texas, and I do regulatory defense, white-collar defense, and advise on cryptocurrency matters, ICOs, and some of the AML issues that come up as well.
So one of the things that, for those that are doing ICOs, or those that may be potentially facing a regulatory inquiry prior to regulatory action, I think it might be helpful for folks to understand what happens when a regulator decides that you're in their crosshairs. Now, while I was still in law school, I clerked at the Oregon Division of Finance and Corporate Securities, which was the state-side regulator for securities enforcement and regulation with the state. So there's the state's regulators and then there's the federal regulators, and when you're dealing with this stuff, you're actually walking in both worlds. And from the state side, I know it was our philosophy, at least from a minimum, that we would put in 150 to 200 hours of investigatory work before we ever sent a letter to the subject of an investigation to let them know that we were looking at them. And one of the reasons we did that was that we wanted to be absolutely sure that if we were going to investigate somebody, that we had something for that. Because subjecting someone to a regulatory investigation means they're spending time, effort, energy, money, resources to respond. So our goal was we better be sure before we put that spotlight on someone. When you were at the SEC, was that the same mentality?
I don't know if the mentality was different, but I can tell you practically it was different. So at the SEC, you can get, a tip or a lead or read an article in the newspaper or in the media, or maybe the examiners in connection with the examination program flag something, and that can then turn into an enforcement investigation, or it actually starts as what's called a matter under inquiry, which is kind of an informal investigation. But either way, that can happen very quickly, and once it does happen, usually the staff will, start gathering information very quickly, and they can reach out to broker-dealers, for example, to get trading records. They can contact the individual they don't have targets, but the potential defendant or the person that they're investigating. Sometimes, depending on the situation, they can reach out to them fairly quickly. Sometimes they may wait. That's often kind of a judgment call based on what the investigator, how they want to handle the case and what they think tactically would make the most sense. But it's kind of a process of gathering information, but you can rest assured that usually pretty quickly there's going to be some requests for information that go out, and they can go out to potentially third parties and potentially the individual that's kind of being investigated. Although there is a little bit of a special hoop they have to go through to actually get subpoena authority.
Yeah. So while I was still a law student and not an attorney, the ethics are a little gray on how much investigatory work I was able to do. The Oregon Division actually had me create an undercover identity, actually had me go out into the marketplace and solicit information from people, find out what they were offering, what was being said, compare that to other things, and actually gathering evidence against people that were trying to sell securities without them even knowing that I was a member or hired or employed by that state regulator. Now, under the American Bar Association, and under U.S. ethics for lawyers, we're not allowed to do that as an attorney of represent that you're someone that you're not. But law enforcement officials and attorneys, and from the U.S. Attorney's Office, you can actually have investigators that are an arm of that investigation or of that inquiry that are undercover, and they have no obligation to tell you that you're being investigated or not. So when you were with the U.S. Attorney's Office or with the SEC, did you ever have any undercover operations that you were running? Not talking specifics or to put anybody at risk or anything, but were those some of the tools that you used?
At the SEC is always going to be transparent about who they are, and you will not have somebody from the SEC call and pretend to be somebody else or take on any kind of an undercover role. So the SEC, if they contact you, they are probably, or at least they should be, telling you, this is so-and-so. I'm an attorney with the U.S. Securities and Exchange Commission in Washington, D.C. We'd like to ask you a few questions or whatever the case may be, but they will be transparent. On the other hand, though, with criminal law enforcement, then you can have agents that operate in an undercover capacity.
So when you're in the securities world or you're crossing into the securities world, as I explained to my clients, you're really simultaneously operating in three different regulatory regimes. You're in an administrative law forum, right? Because the regulator has administrative law authority over your action, or they'll say that they will and gain that authority. You're under a civil law regime because the federal or state regulators have the ability to actually file actions in civil court against you. And then there's the criminal law side, because it's a straight pass-through of information from the state regulator to the state law enforcement agency that they're coordinating with. So when you're walking in these realms of an ICO, and I'm sure you do this as well, I try to advise my clients that you're actually defending against 4 attack vectors, potential attack vectors. There's the administrative side, there's the civil side from the regulator, there's the criminal side from the criminal side, and then there's the 4th, which are the potential claimants or complainants against your ICO that you've sold to, right? Actually, if I think about it, there's a 5th attack vector because it's crypto. And so there's the multiple hack vectors that are coming in order to try to steal whatever token that it is that you've created or get into your wallets, et cetera. So when you're prepping an ICO, prep for 5 different attack vectors for where you're subject to some form of vulnerability. What do you think?
I think it sounds good.
Yeah.
Yeah. This ICO space was largely unregulated. The SEC really made its appearance known in July of this year, which I think really kind of
disagree with that.
What?
I might disagree.
Well, it could be. Certainly, you've got some of those other vectors, but from the SEC side, they had been, quiet. Other than in, I think maybe you've got a particular case involving allegations of fraud, not you, but a client, and that would be a little bit different situation. But as far as kind of the ICO space in and of itself, whether or not the raising of capital for an ICO triggers the federal securities laws, that's something that a lot of folks haven't been, knowledgeable about. There hadn't been guidance out there. And so in July of this year, the SEC actually issued a report. It's called the Dow report, the Dow token report. And it basically flagged this specific issue. And the SEC came out and said, basically, look, they looked at the Dow tokens and made a determination when they applied a test, which is called the Howey test, based on a 1946 Supreme Court case involving citrus groves, but nevertheless, that's the test. They applied it to these particular tokens and determined that they were securities. And as a result of that, we kind of have this fallout now where anybody that's really going to operate in the ICO space, either as an issuer or even a participant, needs to be familiar with that and looking at kind of those underlying issues of, hey, is this ICO, is it a security? Because it has an impact, kind of very broad strokes. It's got an impact on the people that are raising the capital, because if it is a security, then they have to comply with the federal securities laws, and it may have to be registered or exempt from registration. Similarly, even if somebody's just participating in the sale of those, they could have liability under the federal securities laws. And then also, if somebody's investing, that could be a material event to the ICO or the coin if ultimately it's determined that it's a security and wasn't properly registered, and the SEC can come in and take some action.
So let's just for a second. I want to go through and we can kind of bounce back and forth here. I want to look at all the players that are involved in an ICO, and then let's talk about and I don't want to do this whole we're here to scare you kind of a thing, but a lot of folks have tried to say that Bitcoin is unregulated, and my response has been no, there's existing regulatory schemes that Bitcoin has fallen under from the beginning, that it just hasn't been specifically or explicitly enumerated that it was. So let's talk about an advisor to a ICO, right? Typical practice of an ICO is they have their developers and then they have their board of advisors or people that they like to list in their white papers. Some of you may be advisors for ICOs. Under what SEC regulation would an advisor potentially be at risk for an action?
To the extent the advisor, let's just say, knows of misrepresentations or fraud, or there's statements about how the proceeds are going to be used and they're not actually going to be used that way, or they're not in fact used that way, certainly they would be subject to 10b-5 type violations, which would be a fraud charge.
Well,
also,
Go ahead.
Oh, sure.
Sorry.
And to kind of continue that, so that's kind of the egregious stuff. To the extent that maybe there's not fraud, but nevertheless this is a security, if they're participating in the offering, and this is kind of a facts and circumstances type of analysis that needs to be done, but if they somehow are involved in the offering, participating in it, getting people to invest in it, and it turns out that it's a security and it's not properly registered, then they can basically be subject to violations of Section 5 of the Securities Act.
Right, so that's unlicensed,
Right.
unregistered
Right.
securities.
And
what
then
about aider and abetter liability?
That was going to be my next word. So yes, that's a potential too. And generally there's kind of three elements to aiding and abetting. You have to have that primary violation. So there has to be an underlying violation, and that could be kind of a Section 5 unregistered offering. It could be 10b-5 fraud. But if there's an underlying violation and then the person had knowledge of it and substantially assisted of it, those three factors, then they can be charged with aiding and abetting. In the administrative context as well, so the aiding and abetting is kind of a legal term that you find in kind of civil actions. The SEC also has kind of administrative proceedings, so they can bring cases outside of federal district court, and instead they can bring them in their own administrative courts, which kind of creates the potential for a conflict because these judges are actually paid by the SEC, but The theory is that they're also very sophisticated in securities cases because that's all they hear. But regardless, in that capacity, they can bring kind of causing violations. So if the person had such a role where they would have caused the violation, then that can be enough for some exposure as well.
So briefly, can you define scienter?
I guess to make it as simple as possible, basically a bad intent, you know?
Right.
Yep.
Right. So you're steeped in federal law, 10b-5. You know that there is no aiding and abetting liability under 10b-5 without scienter, right?
Correct.
In the state of Oregon, they don't care about scienter. Did you make a statement? Did the statement turn out to be false? Aider and abetter liability. Done. Doesn't matter your intent. The plaintiff's laws in the state of Oregon under ORS 59 are some of the most favorable in the United States. And huge organizations have tried and tried again to wipe that statute out. And it's failed every time. So when I was doing plaintiff securities work in Oregon, sure, I would bring a direct fraud action, but I'd also bring an aider and abetter action against every advisor, every accountant, every attorney, every person that put their name on any offering document or was associated with it, because that's allowed under the Oregon law. Anybody know that? Now you do. Everybody's worried about the federal laws, and they forget about the states. There's 50 other states that are going to bring something against you if you've done something wrong. There's nothing that says, oh, we're going to wait for a federal action to happen. A federal action is a completely different set of laws versus a state action. States aren't going to sit by and wait. There's no double jeopardy for that. A violation of 10b-5 is a separate action to a violation of ORS 59. Two different actions. Two different environments. So when we talk about attack vectors and you talk about where you're selling and what you're doing in securities laws, people think, oh, it's only the Howey test that matters. No, it's just the start. Yeah, that stunned look that you've got, that you just absorb that for a second. So when you're working with a law firm or you're working with a team to try to develop a strategy and you're trying to decide where you're going to sell, when you're going to sell, who you're going to sell to, make sure you're at least working with somebody that knows both federal and state law apply and how those apply. And if you're going to look for an exemption, oh, I'm going to do Reg D, right? What's Regulation D?
So basically there are different exemptions under the federal securities laws. So you can either register an offering of security, which involves a lot of paperwork and time consuming and very expensive, or there can be exceptions to that or exemptions, and Reg D is one of them. So to the extent, for example, the offering is only made available to accredited investors, then only a limited amount of information can be provided and still go through with the offering.
Now, if you're going to make a Reg D filing, you have to file that with the Securities and Exchange Commission. But you're also required to file a Reg D notice filing with every state that you're going to sell to. Yeah, go ahead.
Can you comment on, I mean, it seems like, at least what I've read about is companies who are, well, I thought
That's all right.
enough, but thank you. So it seems like what I've read about is companies who are doing ICOs domiciling in Barbados, Cayman Islands, Hong Kong. Can you comment on the regulatory consequences in terms of selling those tokens to investors or persons in the United States?
Sure. I mean, I think we could look at the Dow token report just as an example. That organization was based in Switzerland, right? But nevertheless, the SEC issued this investigative report, and it's really kind of a warning. They could have taken enforcement action, but I think they wanted to get the word out to the community, essentially, that these are securities, these federal securities laws need to be complied with. So the short answer would be, look, if these offerings are being made available to U.S. investors and U.S. investors are investing in them, then the long arm of the U.S. law can reach them. And you can also look no further than BTCE with the indictment there, and that was based, who knows where, but not in the United States, although there was enough kind of tentacles here in the United States for them to go after that.
So the theory that he's talking about was a case called International Shoe, which established jurisdiction over non-resident defendants. Okay, so for a court or any agency to have jurisdiction over a non-resident defendant within the United States, they look at whether or not there are such minimum contacts as not to offend traditional notions of fair play and substantial justice. When my civil procedure professor told me that one day I would be reciting that in the shower over and over again, he was right, because it matters whether or not there's jurisdiction. What is a minimum contact? Are you benefiting or are you taking advantage of the benefits and protections of the laws of the United States? So when you sell a token or you sell a coin into the United States, you are taking advantage of the benefits of somebody's money in the United States. Just one token, I would argue, is sufficient for any regulatory authority in the United States to have some form of jurisdiction over the foreign seller, because that's a minimum contact. Now, whether or not you intended to do that or not, whether or not you put in AML KYC requirements and CAPTCHA and everything else that determines, or at least attempts to determine whether or not they're located jurisdictionally within the United States, I think there's really no exact guidance right now on how many efforts you must take to try to deter. I know that there's a bounty program for ICOs where at least everybody knows Junseth, right? Yes, raise hands, Junseth. There you go, there's one. From the Bitcoin Uncensored podcasts, his goal in busting ICOs is he tells everybody that's trying to do an ICO and not sell to the United States, he makes it a point to actually acquire one of the coins. Just to prove how easy it is, and it's really easy. So when you're talking about jurisdictional requirements selling outside in, it's not going to matter so long as there's sufficient minimum contacts. Yeah? All right.
Could the SEC just skip the whole investigation warning letter process and go right to, we'll say endgame, just arrests?
The SEC does not have criminal jurisdiction, so they would not arrest anybody. But the SEC, in an emergency situation, they can move very quickly and file cases without providing notice to a proposed defendant that they're going to bring a case. Now, the typical process would be that if the SEC conducts an investigation, determines that they're going to bring a case against somebody, they typically provide what's called a Wells notice to the individual that's about to get sued, and they basically tell the person, hey, look, we're going to recommend to the commission that the following case be brought. These are the violations. Generally, this is the factual basis for it, and they provide that notice to the individual. The individual or the company, would then have the opportunity to provide what's called a Wells response, and the response would be, hey, here's why you shouldn't bring a case, here's the law, here are the facts, it really isn't a violation, this really wasn't a security, there was no scienter or bad intent to defraud anybody, and that would then get presented to the staff, who would then present it to the commission, and ultimately they would make a decision about whether or not they wanted to bring that case or not. And sometimes if they're, effectively written, they can be successful in either, killing the case altogether or, reducing the sanctions or charges potentially. But on the other hand, if let's say there's an egregious offering fraud and money's about to leave the country, they can go and file an emergency case in federal court seeking a TRO and an asset freeze to shut it down, and the person may not know about it because they may not want the person to know about it, because otherwise they'd maybe wire the money out sooner, or they'd get it out of the bank and leave the country. So hope that answers your question.
So just the...
Hold on, just briefly on that. In the case of SEC v. Shavers, which I defended Shavers in that case, which was the first alleged Bitcoin Ponzi scheme in the United States, then that case was brought in 2013 and resolved in 2014. The SEC did just that. They walked into the courthouse in McKinney, Texas, which was the jurisdiction of the defendant. They asked for a restraining order, they filed a complaint, and they asked for and received a complete asset freeze of all of his assets before he was ever served with a copy of the complaint. So what's the ramification of that? I'm a lawyer, right? I've got a client walks in, says, can you defend me? And I say, great, what's your ability to pay? Well, the SEC froze all my assets. There's the door. It's an incredible powerful tool that the SEC has to be able to get that freeze, because it effectively is a taking of your property without you knowing of it, and it limits your ability to actually recover that, defend yourself with that, because there's very few attorneys in their right mind, and apparently I'm not in my right mind because I defended shavers without being paid, that would actually take that case knowing that those assets are frozen. The SEC has amazing tools at their disposal. They write the rules. They get deference to the rules. All they have to do is check their boxes and follow their process, and the cards, wouldn't you agree, are just stacked completely in their favor, don't you think?
Well, certainly the SEC is going to have a lot of resources behind them. There's no doubt about that. And I'll be very tactful about the answer to that question. You know, I would say, look, the reality is you're dealing with, it's the government. And, you know, they have the ability to conduct investigations. They have very deep pockets, or some would argue maybe unlimited resources. So that gives them, you know, an advantage. It's obviously much more difficult for an individual to defend themselves in a regulatory inquiry or a white-collar case when they don't have money. And to the extent that the SEC is successful in getting kind of that emergency relief from a district court judge, and keep in mind, it's not just the SEC that goes out there and unilaterally makes the decision. The federal district court judge has to approve it. But that is definitely the SEC at its kind of most powerful. The other component is in a really egregious case where there's funds or assets to be distributed, they can actually get a receiver appointed, and the receiver basically steps into the shoes of the defendant. The defendant can be the individual and the entity, and takes over all their assets, and basically has the responsibility then under the court's supervision to manage those assets and liquidate those assets for the benefit of defrauded investors. But what that translates to literally is when the receiver shows up with the marshals, you know, they'll ask for the guy's wallet, they'll kick him out of the house if there's equity in the house, and all those types of things are possible.
Who has the mic?
Yeah. So just to follow up on the question, when you said that as long as the token was sold to a U.S. a person in the U.S., then the law applies to them. What if the issuer makes sure that there were no U.S. investors in the sale, but then one of their investors then resells that token to a U.S. investor? Now, does the issuer have that law? He's not the one that sold it to the U.S. investor. It was resold to an investor. Does he have liability?
Well, one of the things that you need to look at when you're actually doing an app token, right, which kind of crosses into this, and you're saying, I'm not going to give my licensed software to U.S. people for whatever reason in your end user agreement or your terms and use agreement, right? I think a wonderful risk mitigation tool would be to say that there is a restriction on transfer of asset, that any transfer of asset to a U.S. citizen would therefore void your license for your software application license. Because it's software, right? Right? So you have a right to control your software license, right? I mean, we have laws and structures and constructs that already exist to handle these things. Bitcoin is not new. It's intellectual property you're talking about, and controlling intellectual property rights. So control your intellectual property rights. Make sense? But if it's a security, now it's not a piece of software, is it? Well, you know, ask for permission, beg for forgiveness, you do your best. Right? And I don't have an exact answer for you, because what we don't have right now is a specific look at how a subsequent secondary market created into a secondary market then creates whatever rights or liability to a cryptocurrency asset. That just hasn't been brought yet. So generally speaking, when people are selling securities, they're complying and they're registering. Right? You're talking about a different game theory scenario where someone has said, I'm specifically trying to avoid regulation by not selling in the United States, and then somebody else usurped that. So I think you have a defensible position, at least, to a regulator saying, look, I did what I could, but they sold it. Well, you can put a lockup on that and say, no, any subsequent transfer out does an automatic burn of your token. Can't you put that in your terms of agreement? Can't you do that? You don't have to know about it. Put it in the user agreement. I'm sorry? Doesn't it, though? Yeah. Yeah. Comply or not comply? That was the first question we were talking about in the regulatory panel, right? So you can spend all the time that you're thinking about with your ICOs of how do I PAMP in less than 24 hours and get 230 million like Tezos, right? How do I do that? And the best way to do that is have it open to every single market possible. Tell everybody it's a contribution. Come on. Did you go into the Slack channel for Tezos? I did. I was there. Anybody else go into the Slack channel for Tezos? Look, if you typed in, hey, I'm curious about investing in Tezos, the Slack Tezos bot would come up. Thank you for your consideration of investing in Tezos. However, it is not an investment, it is a contribution. Right? And I'm like, are you kidding me? Of course it's an investment, right? And I typed that out. It is not an investment, it is a contribution, right? A little Slack bot would sit there, and every time you wrote the word investment, I really like, key lime pie investment. Tezos is not an investment, it is a contribution, right? So every time that came up, and then I was actually in there talking with people that were alleged contributors. I said, you guys know that it's an investment, right? Tezos is not an investment, it's a contribution. And they said, and the response was, of course we do, but we don't use the word blank, blank, blank because we're sick of the Slack bot. Right? So, I mean, you can take all those efforts, right? You can have a Slack bot. You can try to call it a contribution. You can try to do all those things. I said earlier after our previous panel, and some of you may have heard me say this, but you can't put a cat in a dog suit and make a cat bark, right? And that's what a regulator is going to look at. You can try to put a cat in a dog suit, but at the end of the day, the regulator's a little bit smarter than you think, right? They're going to look at it and go, we've seen this before. We saw it either in gold certificates, or we saw it in oil futures, or we saw it in this scheme or that scheme, and they're going to walk to the judge and they're going to say, Judge, look, there's nothing new about this. We've been doing this since 1940. This is what this is, and here's the precedent for it, and they do apples to apples, and at that point you're left going, but it's a dog. It's a cat, right?
Yeah, you can put in or take out words that would suggest it's a security, replace coin, or replace investment, security, take out all those words, try to dress it up, but ultimately what the SEC is going to look at is they're going to look at the substance of it and make a determination about whether or not it's an investment. And if they include decide that it's an investment contract, then they could potentially bring enforcement action. But, taking those steps isn't going to inoculate it. The other thing is it's also very difficult to do that because the SEC isn't just going to take a white paper and review the white paper and then, that's it. I guess it doesn't say investment, so let's go look at something else, They're going to go do other things, and they're going to look on kind of YouTube. They're going to go on the Google.
Says it's not an investment.
Right.
The white paper says it's not
Right.
an investment.
So they will look beyond that, and even in that Dow token report, there's specific cites to quotes from the founders where they talked about it being like a dividend and different things like that, some of that language, but these were in presentations. So the SEC didn't just take the white paper and decide to, close the case and move on. What they did is they said, well, okay, we got this white paper, now let's really dig in. Let's, Google it. Let's look at the presentations. Let's look at other materials. Let's look at emails. Maybe, during the course of their investigation, they requested some of that stuff. I know the SEC brought an enforcement case regarding like a real estate coin and diamond-related coin. It was like RE coin. Well, you look in that complaint, it talks about emails. They got other documentation that they looked at to make that determination, and they're going to look at those types of things when they come to a conclusion about, are we going to, bring a case, and is this ultimately something that we believe is a security?
Reddit channels, Facebook
Yep.
pages, Slack channels, Telegram groups, texts, tweets, all of it is discoverable. Who's got the microphone in the crowd? Okay, great, go ahead.
So I know we're talking more on the ICO company sides, but in terms as an investor, what do you guys see in terms of regulations coming down on people who participate in ICOs that may or may not be securities, as well as exchanging them on the exchange? And
Sure. So from at least my understanding of a regulator rubric is that they're not Their job is not to come after you. Their job is to protect you. Okay? So if you're actively trading in these vehicles, you're not the person they're coming after because, quite frankly, they don't have jurisdiction over you. They have jurisdiction over the seller, not the buyer, right? Unless, of course, the buyer is somehow involved in the initial sale. Okay? Would you agree with that?
Well, I think technically, look, they're going to have jurisdiction over any activities relating to securities. So from an investor perspective, let's assume we're talking about kind of a, innocent investor that decides to invest in some, ICO and it goes belly up and they lose their money and the SEC steps in. In that situation, the SEC would look at that investor as basically being a witness probably or a victim, and that's really it. Now, to the extent these are securities and they're being traded, I guess theoretically if the trader were to be engaging in manipulative trading activity or insider trading or something like that in connection with these securities, even if they're quote unquote coins, that would be something obviously the SEC could then go and look at the trader and have some potential liability there for the trader. But in the ICO space, generally, the focus is really going to be more on, who's issuing it, who's participating in the offering, not really looking to go after the investors because they're really the victims in that situation. Either victims because maybe the thing went belly up or because, this was an unregistered offering and they were supposed to get access to certain documentation during kind of a Reg D type offering or registered offering.
We've got about a minute and a half left.
Yeah, so my question was actually kind of similar to his, but if you could expand upon maybe, the SEC and the U.S. federal government's worldwide reach on, people, especially companies that are selling these ICOs, outside the U.S. and they're, making some steps to, to not sell to U.S., investors to try to avoid SEC jurisdiction. Maybe I know there's no set, regulation on how much they have to do to try to avoid it, to avoid U.S. investors. But, what are your best thoughts on that?
Well, we addressed this a little bit earlier when we were talking about minimum contacts and the diligence that ICOs have to go through in order to try to protect themselves if they're trying to avoid U.S. regulation. Simultaneously, when you're trying to avoid U.S. regulation, you are selling a security from somebody else's jurisdiction as well. So just avoiding U.S. regulation doesn't mean that there isn't a regulatory regime that you have to comply with in the jurisdiction that you choose to sell from, okay? Without going into repeating that, because we're at like 20 seconds, and I think we can talk about it a little bit more offline, but I think we already covered some of that information that you were talking about. Time for one last question.
Jordan Balfour, on the pump and dump scheme that the Wolf of Wall Street was based on, claims this is the worst he's ever seen. It will be 10 times worse than the era that he was in. Historically, what other kinds of investment schemes do you think this could compare to? And should we be investing in your litigation finance practice? Secondly, what would be an example, just to use a case study, of a utility token that's really a security token?
So we talked about it before. I think the rubric upon which to look at from a regulatory case that actually was cited in the Dow report is SEC v. Glenn Turner. Okay, if you look at SEC v. Glenn Turner, they said all we were doing is selling tapes, all right? And they were selling motivational tapes, but they had different levels of selling those tapes. And it was when they crossed into the opportunity of revenue sharing through some activities of selling the tapes where they moved into the investment contract realm. Now, realistically speaking, from a regulator standpoint, and if I'm a regulator and I'm checking my boxes, because if I check my boxes, I get to keep moving through. If I can't check a box and I want to go outside of my box, I have to go to my boss or my boss's boss to try to bypass that and convince them that the regulator needs to move forward in an action that may be risky because it's outside of our check boxes. It would seem that the low-hanging fruit, which are ICOs that are clearly fraud, like NVO, I think the NVO token was clearly fraud. I think Tezos was an abuse of, really abusive of putting a cat in a dog suit. just, the materially false statements that they were making within their terms and use, the Slack channel, just trying to cover it up as much as they were covering it up. I think you could claim that those are materially false statements in connection with the sale of a security. But I think without naming anything specifically of what is a case study to look at of an existing token sale that's out there right now that claimed to be an app token, but the SEC came back and said, no, it's not. I don't think we have that definition yet because there hasn't been enough time for the investigation phase to go through into the full enforcement phase, into either administrative order through ALJ or through civil action that I know of. Do you know of any specifically that have gone that full route yet?
Yeah, not that I can think of. I think that token issue, though, the ultimate issue is going to be, again, you got to look at that piece of it and say, is this really a true utility token? Does it have real utility? Or are people actually purchasing it because they're looking to make a profit by selling it later? I think we have officially run out of time, but thank you all. If you have any questions, we'll be happy to stick around.